the jail hear me?
Hear us?
Yes, I can hear you. That's great. Excellent. And you were visible there for a second. There we go. That's great. Thank you.
You're welcome.
We will go on the record in the matter 24 CF 143, State of Wisconsin versus Michael Winquist. The state appears through District Attorney Kevin Schmidt in person. We have Eugene Harrington, Defense Counsel in person. Michael Winquist appears by video conferencing in custody in Burnett County Jail. We're set here for a status conference. Mr. Harrington, can you please update the court?
Case is settled, Judge.
Can you please provide the court with the agreement that's been reached?
Count one will be amended to allege second-degree reckless injury contrary to 940.23 sub 2.
940.23
sub 2.
sub 2, okay.
With a dangerous weapon modifier. Maximum penalty for that offense is 12 and a half years plus 5, 17 and a half years is the max. Actually, it's 12 and a half years is the max confinement. He'll also plead guilty to count 2, possession of a firearm by a felon. That's one count of that. The other counts will be dismissed. Parties will request a pre-sentence investigation. Both parties free to argue at sentencing. Propose that the parties agree to recommend concurrent sentences as to the amended count 1 and count 2. Mr. Winquist will prepay $10,000 as and for partial restitution. I've now checked with the veteran service officer. Once he's confined to a correctional facility on a sentence, whether it's a jail or prison, 60 days thereafter, he will lose the vast majority of his VA benefits. He retains 10%. Upon discharge from incarceration, monthly restitution will again be reviewed and extended as the facts may warrant. Conditions of extended supervision or probation include the standard conditions: no contact with the victim, her family, or other friends identified through discovery. If acceptable, a list of persons will be prepared and presented to the court at sentencing. The parties will prepare a stipulation of facts which support the factual basis for the conviction. And I think I have accurately set forth the plea agreement. Mr. Schmidt?
So it's free to argue.
Yes.
But the state is not capped. The state can argue all the way up to the maximum possible penalty, except that the agreement is concurrent.
Yes.
Ms. Bauer? I'm going to guess that the agreement was not discussed with the victim prior to.
Yes, it was. And I don't agree with that.
All right, the victim needs to come up here to the black desk, and you either state your name or just your initials, whatever you feel most comfortable with.
My name is Christina Fickbaum.
And I'm going to say that I know that you're anxious and you seem a little frustrated. But remember, please speak slowly, and please make sure that you can speak loud enough so that my court reporter can hear, and that so I can hear, okay?
I was discussed with their agreement and I don't agree with it because 17 years is 17 years. Congratulations for Max. My feeling is that my hearing is gone forever. I have serious brain injuries that they've already diagnosed. That is forever. Right now, my nerves are dying out in my legs. Long-term looks at like dementia and possible wheelchair. I have surgeries coming up left and right, but that's forever. My son, you can't erase it. And he has nothing for doing it in front of my son. It's just not fair. For the rest of my life. That's all I have to say.
Thank you. Let me go have a seat. Thank you. Mr. Schmidt, would you feel more comfortable and Mr. Harrington more comfortable briefing, or not briefing, but just doing a memorandum as to why this is in the public interest? Or would you like to make argument here today
I can do it
for
today.
consideration?
I am not surprised with this. My proposal to Mr. Schmidt from February 28th about the facts to support the conviction, I would prefer to write those down and outline to the court why we think this is an appropriate disposition or appropriate plea. The facts will tie into the discovery. My proposal to Mr. Schmidt then was that I would prepare the statement of facts, which will support the conviction, and that he and I would talk those over, negotiate what the facts were before the plea came about, and that was the basis for our agreement. And I think that's what I'd like to do, Judge.
And I actually prefer it in writing as well so that I can digest it, because I only know the facts as they're laid out in the criminal complaint. And that's the only facts that I know from, I would say, the police standpoint and the state standpoint. So how long do you need to prepare a written memorandum or brief as to why you believe that this agreement is in the public interest?
What I'd like to do is, if you could give me 2 weeks, then I will prepare a draft. I will get it to Mr. Schmidt. And Mr. Schmidt may not agree with some of those facts, which is what was originally contemplated. And I'll submit it there after. If I could have until April 18th. And then I'd suggest we set this for a plea after that.
I think Attorney Harrington and the court are referring to two different things. Attorney Harrington's talking about what the factual basis of the plea is. The court's doing the public interest inquiry right now and asking if we want to give a statement of why the agreement's consistent with the public interest.
Well,
That's why I'm saying
one and
I
the
can do
same.
this today.
yeah, I assume that they were one and the same, but
I believe that they would be one and the same, because if you're going to both the state as well as the defense stipulate as to the factual basis, then that would mean that you're stipulating as to the facts, and that would be why. And plus, you'll make argument as to why you believe that the agreement is in the public interest, because you're going to have the stipulation as to fact, and you'll have your little argument as to why. Or not little, you'll have a argument as to why you believe that the court should accept the agreement that's been reached, and why you believe that it is in the public interest to amend count 1 and to accept a plea for the amendment and for count 2. But I believe, as Mr. Harrington has said, if you, the state and defense, have, as part of your agreement, agreed that you both are going to stipulate as to facts to present to the court for a plea and sentencing, I think that it's pretty vital as to the public interest. So you want until the 18th?
18th of April is, well, that's Good Friday.
Yeah. Why don't we do until the 28th of April?
Fair enough.
And then Mr. Schmidt, how about May 12th?
Mr. Schmidt and I are gonna,
You're just
Yeah,
gonna work
it-
together?
we're gonna work.
It has to be stipulated, it has to be one
okay.
document.
All right, so you'll work together? Okay, so then April 28th. And then let's get a status date. Can you do May 8th at 11:45? All right, May 8th at 11:45.
Can
No,
we do that that's that board of directors that I sit on. We meet at 9 o'clock that morning, 11:45, 11 might be kind of nip and tuck.
What about May 7th at 11:45?
May 7th, 11:45 works.
All right, so May 7th, 11:45. And the court will then have had an opportunity to review the document filed by both sides. Well, together. Anything further from either side?
No, Your Honor.
No, Judge.
Okay. Then we are adjourned.